Sure, you have a record.
Thank you. All right, we're back on the record. Case number 23 CRE 233, State versus Banner, Day 3. All parties are present. Counsel. Mr. Crosby, you have all 9 jurors?
Yes.
Would you return to the courtroom, please? Any matters the court needs to address first?
No.
No, Judge.
All rise for the jury, please.
Be seated, everyone. The court would note all 9 jurors have returned from the evening of their own lives and are back here today to assist with this case. I believe, Attorney Mayor, you were about to call your second witness.
Yes, John, thank you. We call Lieutenant Sims.
All my friend, I hope is jury verdict draft number 3.
Okay. The jury instruction?
Jury instructions.
Okay.
I couldn't wait for printing longer. It wasn't working.
So you want some copies?
I need 2 copies if you don't mind.
Absolutely.
Hopefully they'll be printed this time.
I will be.
There's no rush.
I'll get it, but I'll be open.
I just wanted to give it to counsel as soon as I can.
Absolutely.
Right there's fine, sir. You swear affirm the testimony you're about to give in this case be the truth, whole truth, nothing but the truth. If so, say I do.
I do.
Have a seat, Kat. The microphone, just speak.
Main court, Attorney Mayor.
Thank you, Your Honor. Can you state your name for the court announcing?
Donald Sims, S-I-M-S,
And where are you currently employed?
Ashland County Sheriff's Office,
And how long have you been with the Ashland County Sheriff's Office?
28 years.
And in what capacities have you been in the office for those 28 years?
Oh, just about everything. I did some part-time dispatching in the beginning. I was a full-time corrections officer. I was a patrol deputy. I was a sergeant in the enforcement division. I worked for the child support enforcement. I was a patrol lieutenant in the enforcement division, and now I'm a captain of the enforcement division.
Oh, I'm sorry. You're a captain now?
Yeah.
Okay. I prefer to use lieutenant.
I still answer to about everything.
And so you've had the basic training to be a Ohio peace officer?
Yes.
And considering that that wide span of duties, I take it that you have continued with your continuing required education to keep that peace officer's certificate active. Is that correct?
Yes.
Done all required updates and trainings?
Yes.
And basically, what does your current position, what are your duties as the captain in enforcement?
A wide variety of responsibilities. I still handle calls. I still am involved in community policing, crime prevention area, which I've done for many, many years. I'm a supervisor of all of the road patrol people, all the people that drive around in the cars. And my new duties have taken me to be over top of the detective division as well.
Okay. And You are familiar and know Cindy Benner, is that correct?
Yes,
And she's sitting here next to me in the courtroom.
yes.
And, was she already working for the sheriff's office when you started?
Yes.
Okay. And, so you indicated that you are the, supervisor over all road patrol. So would you be an individual that Cindy as a sergeant, if she had complaints, issues, assistance, she would go to you?
Yes.
Is that the chain of command
Yes.
that's appropriate? Okay.
Mhm.
And you also are the person that has done her initial evals, her, I guess, yearly performance evaluations.
Yes.
And would you agree that she has had overall very good evaluations over the years?
I object, Judge. Clear approach.
Sure. Let's see.
And also wants to comment that the jury has so they don't make contacts or
Okay. Are we in?
Yes, I actually have the latest 21, 22 evaluations.
Okay.
Which is interesting.
Well, this is the court's position. I think the defendant has a right to put her character into evidence. Every defendant does. She's being charged with negligence. If she wants to present evidence that she is an outstanding officer, that she has good reviews, that she's not a negligent person as a matter of character, then she has the right to do that. If she does that, she'll open the door to whatever the state has. And, you know, if the state wants to, then go back and rebut that character. I mean, Mr. Long couldn't do that. He couldn't attack her character. But you can make it an issue. You can make it an issue. But I think he has the right to use whatever he has in rebuttal. And that may open all kinds of doors that maybe the court sure doesn't want open. But that's your decision to make. But I think you can do it. I think you can put her character in evidence if you wish.
Thank you.
Yeah, just you guys come back first. I'm still thinking. If it's being offered for some other reason, then, you know, I would listen to that. But to me, it seems like character evidence.
My point was when,
You cannot.
so my point was going to point out that he was discredited.
We have on that. I'm allowed for that limited purpose.
Thank you.
If you repeat your question, Attorney Mayor.
Thank you, Your Honor. In your evaluations, that recently, 21, 22, there were, basically, Cindy got good evaluations for her work performance.
I would assume so. Without looking at them, I couldn't tell you exactly what it is, but I know that there were times where Cindy did do good work, and then, of course, other times, which leads us to today.
Would it help you to refresh your recollection if you took a look at
Oh, yeah, that'd be
the
great.
average, Your Honor?
Would you mark it for me?
I'll mark that as defendant B.
You'll have to pardon me, I might do this for a while.
That's all
Bring my
right. I offer you
glasses.
my glasses, but they
Yeah.
might not look very well on you.
So, what we got here, this is 21, okay. Okay,
Refresh your recollection on those?
yeah.
Okay, and so I guess, basically the question was, has Cindy had overall good evaluations in those 2 years?
Yeah, I noticed, on at least 2022, somehow the, evaluations didn't get, recorded.
Right, I guess I'm looking, yeah, I saw that too, but I'm just noticing,
Yeah,
you made
from what I wrote,
it.
yeah, from what I wrote, yeah, that, you know, that's true and accurate, and as far as 2021, she received some, good marks.
Okay. Now, when it comes to, the process that we're, here today in referring matters, for review, who prepares the documents to be picked up by the investigating officer or to be handed over to the law director?
Who prepares the documents that go to the law director?
Or to whoever's going to investigate? I believe it was,
It'd be the
Detective Dawson.
investigating officers.
So Detective Dawson collected all the documents and all the information for this investigation? Only to know.
In essence, I would suppose, yes, he did collect them. He may have asked, department heads or secretaries or administrative staff to, make copies of this, that, or the other, but at the end of the day, I guess he collected the documents.
Okay, so that's not something you were involved in, copying things and handing them over?
No.
And you are, again, just to make sure, you are the captain over all enforcement, which would include road deputies and patrol, correct?
Yes.
And as that position, you indicated you've been a sergeant before too, right?
Yes.
Is that a sergeant like in charge of a shift?
Yeah, I was actually a sergeant for, I think, 18 years. During that span, I was on all 3 shifts for many years at a time. I guess probably second shift would be the least amount of time, but first and third shift, quite some time.
Okay, then basically as a sergeant, it's your job to supervise the other deputies on that shift, correct?
Yes.
And you also interact as a deputy as well, right?
Yes.
And that as your position as a sergeant, it gives you some discretion when it comes to who to send to what calls or what calls to go to follow up, and is that correct?
Yes.
And then also, your job is, if any of them need assist, have questions, hey, how do I do this, what should I do? You're there to provide that direction as well,
Yes.
correct? Okay.
I guess, well, I don't know if you want me to go more, but
I'm just asking generalities, but if you have something more.
oh, no, I was just to say, I'm still responsible for handling calls at the same time, but in essence also, if they had questions, that's what we were for.
Okay. And you would also, if you noticed something wasn't quite going right, you would basically let them know
Yes,
how to do things correctly.
yes.
Okay. And, and being in the field as long as you have, let's talk about the radios. Your portable radio, you have to have on you at all times, right?
Mhm.
And I see that you have the hand part up by your neck.
Yeah.
Do all the deputies have it up here, or do some of them carry like the big one on the hip?
Well, it's also on there, it's just
Okay.
attached to it.
Okay.
But there's a couple different ways people might wear their radios. They might have an earpiece that goes directly into their ear where they're the only ones that can hear the information coming through the radio. And then there's this style that, everybody can hear it. It's just closer to my head.
And is your phone secured there?
Yeah, it took fairly well. And then there's obviously the kind where nothing's attached to it and it's just down by your hip. So just personal preference about what you want to do with it.
Okay. And with those radios throughout and around the county, do you notice that sometimes there are dead spots for the radio where you don't get service or don't get?
Yeah, there has been, like inside buildings or something like that, or over the years, we've changed our radio, communication style. It's kind of a Mark's radio now, and I'm not really 100% familiar with, that technology, versus the other technology, but, you can talk much further, with the Mark's radios and stuff like that.
Okay. Like over a further distance?
Yeah.
But not necessarily help you inside buildings?
Inside buildings is still kind of, things that are made of, like with metal or whatever.
Now, with the AVL, you're familiar with the AVL system and stuff in the cars, from dispatch to vehicles?
Mhm.
Yeah. I'm sorry.
Yes.
And in your experience, especially as a supervisor, have there been times when either the internet goes out and prevents, so there's a drop in the use of that, if the internet goes out or if
Yes.
they lose GPS connection?
Yes.
Right, okay. If I can have just a moment, Your Honor.
Sure.
I have nothing further, thank you very much.
Madam President, Judge. Captain, I'm showing you my marked stakes, Exhibit 20. Are you familiar with that?
Yes.
Can you tell us what it is?
Be Cindy's evaluation from 2023.
And that evaluation is dated 2023,
Yes.
but the evaluation is for the year 2022.
Yes. Sorry. Yeah.
Would you call that a positive evaluation?
No.
Did you perform that evaluation?
Yes.
Can you read your rater's comments for the jury?
Cindy has lost the respect of her deputies that she supervises for lack of decision-making and for failing to back them up on dangerous calls. Cindy has recently been demoted to deputy after an internal investigation confirmed the claims that Cindy was assigned to the jail.
Captain, you were also questioned about discretion. Is that discretion unlimited for supervising officers?
No, I wouldn't characterize it as that, no.
Do they still have to abide by the policies and procedures of the sheriff's office in exercising that discretion?
Yes.
Nothing further, Judge.
Peter?
Yes, Your Honor. This evaluation was dated January 23rd of this year, is that correct?
Yes.
And that was at a time in which these charges had been referred for investigation and charging, is that correct?
I'm not certain the date on there. I'm sure that there was something going on, obviously, from what I wrote. But I don't know what time or what date specifically that was done.
Okay, thank you, Mr. President.
Captain, thank you. You can stand down and excuse. Further witnesses?
Yes, Your Honor. Deputy Duke, please. Thank you.
Counselor, would you recall Deputy Duke, please?
Yes, sir.
Let's re-swear the witness, Mr. Craftsman.
Yes, sir. Right here, please. Do you swear firm testimony you're about to give in this case be the truth, whole truth, nothing but the truth? Does that say I do? I do. Have a seat, please, sir.
Main question, ma'am.
Thank you. Can you again introduce yourself to the jury?
I'm Garrett Dude. I'm a detective with Ashe County Sheriff's Office.
In November of 2022, what was your position with the Ashe County Sheriff's Office?
I was assigned to second shift as a patrolman.
And you were testifying the other day, correct?
Yes.
And since that time, have you discussed this with any other witnesses or any other people, your testimony or anything?
No.
Okay. By chance, do we have on the exhibit list what time the video stopped of Deputy Dude?
I did not record that.
Did you record it by chance?
It's about 17 minutes.
Okay. I would just like to pick up where we left off and play the video.
Do you have it, Attorney Mayor?
That was just, no, the
Do
video.
you have it, Mr. Craftsman?
Should be in the stack, sir.
Thank you, Your Honor.
Sir, this is marked 11.
Thank you, Mr. Craftsman. States allowed. Can you see, Debbie?
Yes,
Can
sir.
you see?
Okay. Time?
Can you go to, I think, is that the first one or the second? Are there two?
There are two different counters. There's
Okay.
one off the camera, and then there's also one on the status bar. Status bar showing 003.
Right, but is there two, I guess, two separate videos on there? Or is this the only one?
That's the only one that came up.
Because this wasn't what we played before. Is there another?
The other two that I have are, one's the thing that Deputy Wood made using his phone,
Okay.
and the other one is the radio traffic. Those are the only three I have. I think that's marked 11, isn't it?
Yes, sir. It is marked 11.
And 11 is
Do you have both of
identified
them on
as
the disc? Do you know?
It's on there.
the 11/8/23 body cam from Deputy.
Okay.
There may be more than one file on this.
I'll,
Check that.
yeah, I will. Hang on.
I think it goes to about 17 minutes
17 minutes
on this one down here.
Okay.
Thank you.
Yeah, that's close to 1653, sir.
Okay, you can stop it real quick. Deputy, or Detective Duke, this, video that we have up in Key, you did, have a video, camera on you at the time of this traffic stop in November of 2022, is that correct?
Yes, that's my department issued body camera that you're seeing here.
Okay, and when you were here before, we started playing it, right?
Yes.
So I'm just gonna ask you, to make sure to watch this, till the end, and we'll make sure that it is, intact, okay?
Okay.
All right, can you go ahead and, thank you. Can you stop it right there? The picture you just took, was that what you were talking about, the magazine
Yes.
in the roadway? And at this point in time, the, Braxton Yoder, he's still sitting there at the edge, on the edge of the roadway, or is he in a car yet?
No, he's sitting on the edge of the roadway on the ground there.
Okay. And these are all officers can you identify who's the officer on the far right?
On the far right, that's Deputy Wenrick.
Okay. And then there is, Cindy, right?
Yes.
And who's the individual behind Cindy?
On the right,
Almost directly about, yes.
that's a squad member, a volunteer squad member.
Okay. And was he the first one on scene? Do you recall?
I don't recall.
Okay. And who's that to the left of Cindy?
That's a New London police officer.
Okay. And he came in after Cindy got there, right?
Yes.
Okay. And then who is to the far left?
That's another EMS squad member.
Okay. Thank you. Can you go ahead and push play? Can you stop it, please? And that woman sitting up in the hill, is that the driver?
Yes, that's the driver of the vehicle.
And that's the individual that you had testified earlier that was sitting unsecured while you were waiting for backup because you were standing next to the handcuffed Mr. Yoder?
Yes.
Okay. Go ahead and push play again, please. Can you stop it there, please? Can you stop it? The far left, who is the shorter officer? Do you know, is that somebody else that came in?
I don't know his name, but I believe he works in New London as well.
Okay, but that's somebody in addition to who we last saw?
Yes, yes.
Thank you. Go ahead and push play again, please.
I don't know you, you need no more this probably. You got me right, well, you attacked me, so. I can't very much sense. Turn around, you just I'm not lying. I'm not lying. What those people did to me. Want to come in my car? Yes. I'm not okay.
Can you stop it right there? We saw, was that Deputy Wyrick taking Braxton Yoder to his car?
Deputy Weinrich, yes.
Renwick, I'm sorry. And then we also see Cindy following to assist them, right?
Yes.
Okay, can you please push mic in?
No, not good. Thank you. Oh, there's a bullet in this gun? Oh, really? I didn't even know that. Yeah, there's a bullet for like what? Like 6 on my copper?
You've never verified any of that Bolo information, right?
Well, dispatch would verify once he's identified.
Did the New London officer offer to send you that information or fax it to you?
He would fax it to our dispatch. He wouldn't fax it to me, he would just fax it to our dispatch center.
You did, so you don't recall asking him to fax it to you?
I don't recall specifically asking, no.
Okay. Okay, go ahead and play, please. Stop this. Did you just indicate asking him, did you hear asking him to send you his reports?
Yes.
Okay, go ahead, Mr. Clinton. Can you stop that, please? So who was it that said they didn't know your fax number? Is that Deputy Renwick? Or,
I'm not sure.
okay. But you didn't know it either, though, right?
No, I didn't.
Okay. Yeah, push forward, please.
I dropped it pretty hard. Just make it 2 seconds. You go to jail. You guys know you let me try to fight me. You got all right. Well, he was hiding under the blade in the back seat, and he pulled the gun out of his waistband, I drew on him, and then I didn't see it anymore, and he put his hands up, and then he came out of the car, I stood there with him, He said he had warrants, he didn't want to go to jail. At some point, he grabbed a hold of me, he pushed me, and that's when I wrapped up with him. He started headbutting me, pushing me, trying to bite like me right here, like right here. And I just picked him up and dropped him right here. I dropped him right here. So he was like, he said, like, feel comfortable. He didn't point the gun at me or anything like that. He just, I saw him before I saw it. That's why I drew on. I didn't see him first. Actually, I made contact on the driver's side, and that's all taped up. How many wanted? Does he have any felonies on his record or anything? Like, you guys had no issue up to this point when the brother issue happened? He's in mine. He's with me.
Can you stop for a minute? Is that you spitting?
Yes.
Okay, go ahead. Can you stop it right there, please? Okay, it's a little fuzzy stop, but, up on the grass is still that, driver sitting there, correct?
Yes.
Okay. And to your knowledge, has anybody spoke to her yet at this point?
I'm not sure.
Okay, but you haven't yet.
I haven't, no.
Can you go ahead and push play again, please?
No, not yet. Okay.
Can you stop that, please? And was that the, you were talking to dispatch about her ID,
Yes.
the driver?
Yes.
Did you obtain that ID? Do you know who got that from her?
I'm not sure.
Okay. Go ahead and push play again, please. Yeah, you can stop that. Is that just Cindy asking if you needed any more help?
Yes.
Because she was going to another call?
Yes.
Please push play again. Can you stop
I
there?
didn't see him also.
Now, the individual we see now to the left, is that the trooper that arrived on scene to assist?
Yes.
Thank you. Can you please push it?
In the car. He got that blanket on him, he was all covered up. Yeah. I kind of second guessed myself. I saw he like picked up his shirt at one point, and I saw like, at the time, he never pointed at me, but I saw him remove it. But it went under the blanket so fast, I wasn't 100% sure it was a gun. Then he started to freak out. I drew on him to show me his hands, and he did. But then he leaned back at some point, pulled his shirt up, and I saw it, but I was like standing here. And then he came out, and then we stood up. He's like, I got warrants, man, I got warrants. And then he like started grabbing me and pushing on me, and then he just pushed me. He like tried to push away from me and grabbed him. He tried to headbutt me. Like he opened his mouth and started trying to like bite right here. And we just pushed back and forth, like back here. I picked up and dropped off the pavement over there. And at that point, it's pretty much done.
Can you stop that?
So, yeah, and there's a book.
Now, your comment there, then after I dropped him, then it was pretty much done. Is that, do you meant your confrontation with Mr. Yoder?
Well, just the fight.
Okay. But so he didn't continue to fight you after you dropped him then?
No, he did. He continued to resist.
Okay. So, I guess, what were you talking about when you said it was all over that?
Me talking directly after this is mere seconds after a critical incident. This is fragments of memory. So I said I'm picking up, I dropped him, and it was pretty much over. Like the active fight of him biting me and kicking me and rolling around the ground. That's what I meant.
Okay. Can you please just play again?
Hello from London with suicide by cop. So, I got some medication here, so I'll hang out with you. Yeah, I'll go ahead.
Can you push stop right there again? So the troopers indicate he's going to hang out with you and help you finish the scene, right?
Yes.
Okay. Go ahead and push play, please. Okay. Let's start over again. Is there more to this video? Isn't there a second?
I believe there's more body camera, yes.
Yes. Can you go ahead and kick to the next?
Is Sergeant Banner gone at this point?
Yes, she is. All right. Go.
I'm just curious what the relevance is of the rest of it.
Well, relevance would be the fact that the individual is still sitting by herself over in the grass. I just wanted.
Okay.
Can you go ahead and play that second one? Thank you.
I think that's where he bit me.
Can you hit
Was
stop,
there any
please?
white marks over here?
Who was it that came on saying, dude?
You have to replay it.
Can you remind us again, please?
I think that's where he bit me.
Go all the way to the very, yeah,
Was there like any white
restart.
marks?
Can you stop that? Did you don't know that was?
No.
Okay. Go ahead and push play again, please.
I think that's where he bit me. Is there like any bite marks over here? He like opened his mouth and like. I can see. Is there like
Can you
bite
push
marks?
stop again, please? Where is the driver at this point? The female driver?
At this exact point, I'm not sure.
Was there a time that she ever got up from the hill that you know? From where she was sitting on the hill?
I wasn't watching her the whole time when I was processing the scene. I'm not sure if she
Okay.
was.
Go ahead and push play, please.
You take a picture of that everything, but it's like that's why trying to fight me. He like went. That's right. Why you have
Can you stop it there, please? Do you know who these individuals, the woman on the right and the individual behind them?
Those are more volunteer squad personnel.
Okay, thank you. Go ahead, Mr. Klein.
Well, you indicated like a minute earlier. Yeah, I think actually, right down the stairs. I second guess myself in the car because I walked up on this side initially because she had the light and I couldn't see it in. So I went back. When I heard her talk to someone, I was like, there's no one else in the car. She said she's alone. So I went back, grabbed my flashlight, walked from this side, and went past it, and I could see like a knee underneath the blanket. And I'm like, who is that? I go, there's no one back there, she's my blanket. And I saw it move. So I was like, I started screaming at me. So show me.
You just stopped me. At this time, Sergeant Bennett has left, correct, to go to a burglary call?
Yes.
And is burglary call considered one of those two deputy calls?
It's, yeah, 2 officer call, yes.
Okay. And if you recall that night, the deputies on duty were you, Renwick, and Sergeant Bennett, correct?
Yes.
And Renwick took your arrest to the jail, right?
Yes.
So he was busy.
Yes.
So that left Sergeant Bennett by herself to go to that burglary call?
We would call for additional units.
Okay. Because you were still on this call?
Yes.
Okay. You go ahead and let us.
That's highly irregular. He leans back, and he's like, he's schizophrenic, I have warrants. I couldn't understand his name. I'm like, show me your hand. I'm like, show me your hand. So I draw on him. I move around to the front, and I see him lean up, pull his shirt off. I thought it was a gun, but I didn't. I saw him remove something down and like, get rid of it. Yeah. He never pointed at me or anything. So I see he keeps trying to move, show me your hands, so he kept moving his hands, he leaned up, he's like, I gotta get out, I gotta get out. I put the flashlight on him, he said he kept his shirt pulled out, so I had to step out with me. Because I'm pretty sure it was a gun, but I wasn't like, after the fact, I knew it was a gun, but in that moment, I wasn't like 100, I saw the metallic. So, he stepped out, he was like, I have warrants, and he just like pushes me, grabs a hold of me, we start wrestling, we go down the ground, he stands back up, he like half headbutts me, and then tries like open his mouth and like bite the side of me, so I just picked him up right here, and just grabbed him right here. And then, citizen ran up and helped me. I wish you would have stayed. Yeah. He came out of nowhere. He ran up and helped me handcuff him, and then he was like, I'm gone. He ran back in. They had an additional mag in his pocket. We also came.
Can you get stop, please? At this point, do you know where the female is?
I'm not sure.
Was she authorized to get back in the car?
I didn't personally authorize her. Someone could have, I'm not sure.
Okay, but this is your responsibility call, right? This, you're the, I guess, deputy in charge of this call.
Yes.
Okay. Go ahead, push play, please.
So, I think I picked it up. You already did. I took his pants off. He had a pair of sweatpants off. I took his sweatpants off because I found the mag, and I got to believe that the gun was still on him. So since he had sweatpants off, I actually took his outer pair of pants off so I could search it better. Huh? No, he had like a pair of sweatpants and jeans. So he had like double layers on, so I took the outer layer off and jacket. He's saying
Can you stop that, please? What were you responding to about burglary in progress?
I believe someone asked what else was going on
Okay,
in like the county.
okay. Can you go ahead and hit play, please?
There's a call. Big house. I never did.
I didn't know that either. But I'm glad there is, like you say, yeah.
Those are huge house.
I mean, who's to say that happened at somebody else's house that don't have a bulb? That's scary.
Well, like I said, what happens is I know.
You just have to
When you get the final bags out of the spot.
Bill, what's the status for Exeter or Lorraine County?
It's what's in my house tonight.
You don't tell them how many blocks left.
Trying to ask for forgiveness, but
Because they're walking down the street. Oh, okay. Okay. Okay, would you finish? Thank you. Thank you. And thank you. Yeah, thank you. Thank you. So why didn't you tell me you were alone?
Stop right there, please.
Huh?
Do you know where she came from?
It looks like she was standing next to the car.
Okay. No law enforcement around her or nobody watching her, right?
Well, we were standing there with her.
Can you back that up about a minute?
So why didn't you tell me you were alone?
Okay, stop it, please. So there, when you said we were all standing there with her, are you talking about I guess the squad crew that you were talking with?
Yes, when we were talking, looks like she was right there, and then when I walked around to my car, she's still within my view through the window.
Okay, and how did she get that clipboard?
That's a written statement form.
Right, who gave it to her?
I'm not sure.
You did know.
No.
Okay, go ahead and keep playing, please.
Oh, listen, you've been right to me silent, and you said you would be against the law. You're right to answer any question. You got a form only 22 to say your rights. Okay. So what you tell me was not in the, like, you're not alone. That's just my point. It's clear he was obviously in there, correct? So, you know he had the gun?
No, I didn't know he did not. I know he usually carries it on him, right? actually did have my hair back.
Did he say anything when I walked up? Like he was gonna shoot me or?
Can you stop it right here? Is it fair to say that throughout this entire thing, you had no concern about her harming you or doing anything, to cause you concern?
At this point, yes.
And the point you were sitting by yourself up on the hill?
Till the point when we had more units and command presence there. Once we had command presence there, I wasn't concerned about her harming me anymore.
But now that your command presence is all gone, you're still not concerned, so you're in there searching the car?
Yeah, at this point, I'm not concerned, no.
Okay, go ahead and push play, please. Can you push stop, please? At this time, you have the post is still there backing you up to assist, right?
I'm not sure.
If they were, wouldn't it be prudent to have them assist you in this, in searching the car and getting the call done so you can go and help on another call?
I was trying to get through the call and get it done.
As fast as you could?
Within reason, yes.
Okay, go ahead and put play here.
She worried about Charles Wilkins? Yeah. Huh? Well, in this car. Listen to me. Well, he voluntarily got out of the car.
After that, if you would just listen in the first place and know your soul, I don't think it is what happened.
Well, he was fine until he pushed me. And then he believed he had a warrant, I guess. So he said, I have a warrant. So I think he was going to try and run because he tried to get away from me there. And he gave me a headbutt. And he tried to bite me. I don't know what that was about.
Okay.
I'm good. Does he have a mental health crisis? He's saying schizophrenic.
He's schizophrenic. He's been in a mental health before. This was all before I met him. I just had him.
Is he like a 10 cop before?
No. I've known him. And I've known him before that I never knew he had. He tells me a lot of stories, but I've never known him or heard that he had.
Okay. Well, you're free to go. If you want to pick up the juice and stuff. Okay?
And at the time of the end of this video, is that when you cleared the call?
Yeah, I could.
Okay. And in reviewing what you've seen, is it a true and accurate depiction of the events of that evening?
Yes.
Hang on a moment, please.
Sure.
Your Honor, I have nothing further at this time, thank you.
Ross?
Morning, Detective.
Morning.
We saw you photograph a magazine. Was that in between your patrol vehicle and the vehicle you stopped for the headlight?
Yes.
For those on the jury that might not be familiar, a magazine holds ammunition or bullets, is that right?
Yes, it does.
That would then go into the magazine well of the firearm and feed ammunition through that firearm.
Yes.
That's what the suspect that you were wrestling with had on his person.
Yes.
Did you know if he had a firearm in addition to that magazine on his person at the time that you were wrestling with him?
At the time, no.
You were asking questions about being concerned for your safety from the female driver. Was there a difference in the concern for your safety from her after the firearm had been secured versus before?
Yes.
What was your concern with her when the firearm still had not been secured?
The concern was, I didn't know who she was. I didn't know her relation to the suspect. I didn't know if they were family members. I had no idea what was going on between them. So she was still an inherent threat until I could prove otherwise and get more units there for command presence.
At some point when other units arrived, was someone assigned to monitor her?
Yes, when the other units arrived, we hold a command presence. When the other officers are there, I'm processing the scene and an officer staying with him and other officers watching her just to make sure the scene stays secured while we're processing it.
We heard you on the video say that a citizen stopped by and helped you cuff Mr. Yoder.
Yes.
Was it nice to have that assistance?
Yes, it was.
Any time during this video did you hear anything from Deputy Benner that sounded like a directive to you?
I did not.
Detective, while you were on second shift at the sheriff's office as a road deputy, how long did you work with Sergeant Benner?
Around 3.5 years.
The case that involves you, Detective, the defendant said that she was at home on lunch. Was that a common occurrence for her?
Yes.
How often would she eat lunch at home?
I would say multiple times a week, throughout the week during shift.
And during the 3.5 years that you worked with her, did you have occasion to communicate by radio when she was at lunch?
Yes.
Ever have any issues communicating with the defendant when she's at home at lunch?
No.
Nothing further, Judge.
Thank you, Ms. Flynn. Redirect?
Yes, John, thank you. When you had Braxton get out of the back of the car, didn't you indicate that you had told him what you thought may have been a gun? You weren't sure that he took and wrapped up in a blanket or put under a blanket?
Yes.
Okay. And the question when other units began to arrive, you didn't designate anybody to go sit and watch the young lady on the hill. You basically just figured with officers being there, that was sufficient.
When we work together as officers, and you work together for years, when people show up to calls, it's just automatic. We don't have to tell people, hey, you need to do this, you need to do that. People show up and just do the job because we've been working together for a long time. It's just, we know what to do.
And then you were asked about a directive. Sergeant Benner informed you about the need to take Braxton to the hospital versus jail, right?
Yes,
Okay. And you chose to take him to jail, or directed him to go to jail?
yes,
Okay. And Sergeant Benner was your sergeant supervisor?
yes.
And, I'm nothing, brother. Thanks.
Is that it? Forgot to do your anticipated
Yes,
call?
I do not anticipate.
If officer calling. Detective, your excuse. Thank you for being here. Everyone witnesses.
Your Honor, if I can just take a few moments to.
Sure. You want to do that off the record?
I would like to, please.
All right, well, we're gonna take a break while Attorney Merrick converses with the client. Before we do that, I need to make the jury aware of something that's happened in the case. And that is that yesterday, outside the presence of you folks, the court dismissed count 2 and count 3 of the complaint. And those are the counts that pertain to the events of, count 2 pertains to October 27th, 2022, which is the alleged domestic violence situation that occurred while Sergeant Benner was on a special assignment at the trick-or-treat. Count 3 was the November 2nd, 2022 incident when there was a report of a male allegedly threatening suicide with a firearm. That case, those 2 counts were dismissed by the state, by the court, but not by the state. The reason I'm raising that is that obviously the other 2 counts remain. Count 1 and count 4 remain pending, and count 1 and count 4 will need to be decided by you folks. And at some point today, the case is going to be concluded, the presentation of evidence will be concluded, and the court will be presenting the case and instructions of law to the jury for resolution of those other 2 cases. Count 2 and count 3 are not going to be decided by you because I've dismissed them. Now, it is very important that the jury not speculate as to why the court dismissed those counts. It is very important that the jury not draw any inferences from that. In other words, you have to decide count 1 and count 4 based on the evidence that you hear in the trial and based on the instructions of law that the court gives you, as though the court had not dismissed those other 2 counts, as though those other 2 counts never existed. They cannot affect you in any way. Now, there are times when the court has to make decisions about charges, and I felt that was one of those times. So that does not affect your duty to decide those cases, those other 2 counts. It does not affect your ability to do so, and you're not to speculate. It's not to affect you in any way. You're just to disregard that and deal with count 1 and count 4 as though count 2 and count 3 never existed at all. Those counts are going to come to you, and as the jury, you will decide them. And what the court did with the other 2 counts has nothing to do with that process at all. Now, at this time, I think we're going to take a little recess for about 10 minutes or so Attorney Merrick can decide what she wants to do next.
Thank you, Your Honor.
All right, please. Sir, you have a record?
Ready to proceed, Attorney Merrick?
Yes, Your Honor.
This one.
Yes.
Your return to jury, please.
Yes.
Well, yeah, hold on, just, we, at this time, I've talked with my client, and we are prepared to rest with the submission of our.
Okay, you want to deal with the exhibits first then?
That's what I was thinking.
I appreciate that. I only have 2 marked by you, Attorney Merrick.
Yes, and actually, Your Honor, I'm not even asking for one, it was identification. In fact, I believe Attorney Malone has that same exhibit as his,
Right.
so I'll just be asking for defendants.
Defendant B, which is the evaluation.
Yes.
Any objection?
No.
All right, he's admitted without objection. I'm not sure I have it though, guys.
Yep, it's right here. I didn't have a sticker though, so I just put defendant B on. So.
Thank you. Ms. Crouch, you want to return to jury, please?
Yes, sir.
seated, everyone, please. All right, we are back on the record, 23 CRD 00233, State versus Cynthia Jo Benner, Defense President Counsel. Mr. Lawrence, on behalf of the state. At this point, Attorney Mayor, defense rests.
It does, Your Honor. Thank you very much.
Mr. Munn, you going to be presenting any rebuttal evidence?
No, Your Honor.
All right. Well, ladies and gentlemen, that brings us, I know it's been 2.5 longish days, but I think counsel have done, both attorneys have done an outstanding job of getting us to this point very efficiently. We've heard from a lot of witnesses, we've heard a lot of evidence. That process is now concluded, and there are really only 3 things that remain to do. The attorneys need to make their closing arguments to the jury, and the court needs to instruct you as to the law that will apply in this case. And then the final thing that needs to happen is for you to deliberate on count 1 and count 4 and reach your verdicts with respect to those counts. Normally, it's practice to give the attorneys some time before we close to collect their thoughts and prepare. I know we just took a break, but what's the state's position on that? Are you ready to close, Mr. Moon?
I am, Judge.
Are you, Attorney Mayor?
Yes, Your Honor.
All right. There's a lot of evidence, there's a lot of witnesses, and there's a lot to talk about. Do you think that you can do closing in half an hour, Mr. Moon?
I might need 10 minutes.
Half an hour?
Yeah.
I'm going to give you half an hour, whether you need it or not. You're reserving the unused portion for rebuttal, Mr.
Yes,
Moon.
Judge.
May proceed.
Thank you. Ladies and gentlemen, on behalf of myself, Detective Dawson, the state of Ohio, I want to thank you for your service on this jury. In my career, I haven't had a 3-day trial in this court. I've never even heard of one, so I know there's a lot that you guys have given up to be here, so again, I appreciate that. As the judge told you, we're here on 2 counts, and the first count pertains to the deer carcass call. And you'll have all these exhibits back there with you in the jury room when you deliberate. And this is on November 3rd, 2021. Cynthia Benner, who is the sergeant, she's got the central zone. There's another deputy, the north zone. Deputy Taylor's in the south zone. She takes a deer carcass call, which you've heard, very low priority call. She's dispatched to that at 16:06 or 4:06 in the afternoon. She arrives on scene 16:33. While she's en route to that call, another call comes in, all call from dispatch. And it says, all call 34, push grandfather down, possible hand fracture. That's at 16:16 or 4:16 p.m. As the sergeant and supervisor in the central zone, the closest deputy to make that 2-deputy call in the south zone, she completely disregards it. She goes, issues a deer carcass receipt to Mr. Blake, who should have gotten this. Instead, she asked him, go get a signature from the Amish guy, who he intends to give it to. And you'll have this back there with you too. It states 12. Look at it. Nowhere on this is there a spot for a signature for anyone who's receiving that deer. She sends them there so she can take longer on the call. She doesn't have to go to the domestic. She's been doing this a long time, and she even got positive reviews up through 2021. She knew what she was doing. She knew the policies and procedures of the sheriff's office, and she completely disregarded them. She knew she should have dropped the deer carcass call, went to the high priority call, and assist Deputy Taylor. Count 4, this is the one that we've seen all of Duke's body cam footage on. She's at her house, eating lunch, and we saw on his body cam, he sends out a request for an additional unit. And you heard him testify, Deputy Leonard testify, that priority 10 needs to get here now, I need help. She does nothing to answer, then disregards it, until dispatch has to reach out to her individually, and finally she responds. So I don't know if the defense says, I didn't hear the first one, I didn't get it. Deputy Duke testifies she's been at her house at lunch, never had a problem communicating with her at all. The deputy that's in the south, Winrick, he got it on his radio. Dispatcher in the city, they got it. Hell, another agency in another county, they got it. That's how they respond. So she gets there, we know from her GPS records, she gets there in 5 minutes. And maybe the defense says, well, I didn't think it was a priority call, that's why I waited 6 minutes to leave my house. Well, then why are you driving 105 miles an hour to get there? We know from his body cam, the call out for help, and the time she arrived, about 11 minutes and 11 seconds. She gets there in 5, so she took 6 minutes, apparently putting on her belt and vest. Deputy Duke told you that takes seconds, especially when another officer needs you. No issue at all when she gets there. Not even her travel time. It's fine. But when that call goes out, Chief Blake told you, minutes count, seconds count in that situation. Especially when another officer is struggling with strong suspect. So this issue with the radios. She's at her house, eating lunch, possibly not get the first one. She's doing the exact same thing a couple minutes later, then she responds. Same thing when she's traveling from where she was at to the deer carcass call. She's in her car, she's got her full array communication gear. She's got her portable radio, she's got the in-car radio, she's got her in-car laptop, all of it. So while she's saying all that just went down, she knew about this message. She disregarded her obligations. She's in derelict on duty. Hold her accountable.
By my count, Mr. Sloan, you have 25 minutes remaining for rebuttal. Attorney Renner?
Thank you. Good morning. On behalf of Cindy and myself, we also thank you greatly for your paying attention and being here for multiple days. I know that's not something that normally happens in this court, but this is a very important case. It's a very important case to Cindy, and we appreciate you being here and listening and doing your part. Because I can see every one of you still have a Team Innocent jersey on. You have a Team Cindy jersey on. Because the state has failed to prove beyond a reasonable doubt the elements of this offense, these two offenses. First of all, just a couple things in closing I want to note. As the trial was going, I just jotted certain words and things down to remind me. My brain is not getting better with age necessarily in memory, but one of the things I thought was really interesting at the time period, because we talked about technology, it can work, it can't work, who knows. We were supposed to have the alert that came on, everybody's phone, everything going off at one time. I think again, does technology always work right? No, because some extra people had their alarm go off a little while later. Again, technology is only as good as it's kept up, as it's put through, and even then, you're going to have your glitches and your issues. And I think except for Deputy Blake, Chief Deputy Blake, I think every other officer or dispatcher acknowledged the fact that internet goes, GPS goes, so those things happen. Radio. Sometimes it works, sometimes it doesn't, depending if you're inside, if you're not. I mean, how many of you have a spot in your house that your cell phone works great in, but if you move into another room, it's like, what the heck happened? It doesn't work. Same with the radio. All the officers have testified, again, except Chief Deputy Blake, that especially when you're inside a residence or a place, they tend to have spots where your radio may not work. And I know the indication is, well, if Cindy had to take time to put her vest in her, Deputy Duke felt it could be done in a couple seconds under a priority. But I will say Deputy Duke is not a woman. And belts and vests and issues are a lot different. Bathroom requirements are different for a woman versus a man. So I think that taking all of that into consideration, especially when I get to the times, Sergeant Benner was not in any way negligent or derelict in her duties going to that call. And I find it very interesting that these counts around the sergeant on the shift is not getting somewhere fast enough. But yet, we just sat and listened to a video stop of Deputy Duke. Granted, the beginning of it was quite, there are issues. It was a lot of adrenaline, a lot of things running. But if you watched how long that took and how many times the story was told, talking to all the other individuals that showed up, and where does Sergeant Benner get called to and have to leave? A burglary in progress. And Deputy Duke indicated that would be a two-man call. Well, the three people on shift, Sergeant Benner, Deputy Duke, and Renwick, Deputy Renwick. Renwick wasn't available. He was on his way to the jail. Duke was still on his call. So Sergeant Benner was left to go to a two-man call by herself. But what was Deputy Duke's response? Well, they get backup. Other backup was called to help her. Well, that's exactly what happened in his case. Other backup was called, but when Cindy did get word and did understand and was made aware, she did it and went as quickly as possible. We'll go over that in just a second. Okay, don't laugh at my creations here. Sorry, Judge.
Oh, that's all right. I guess I don't necessarily.
You can hear me. This is so I don't miss anything. Okay, basically to me what this case is about is discretion. We have a sergeant, a supervisor on second shift. Discretion. And we've heard delegation. We've heard lots of the sergeants and deputies, yes, and even dispatchers. Yes, they have the right, they delegate. They're the supervisor. Neither one of these calls was dispatched directly to Sergeant Benner. The first call, she was already on her way. Granted, it was a deer carcass, a deer call, but she was already on her way. And on November 8th, 2022, this was Deputy Duke's stop. It was not dispatched to her, but she ended up being on her way. Let's talk about count one first. We have Sergeant Benner at 16:06 dispatched to the deer call. She arrives on scene at 16:33, and here the testimony from Mr. Blake is that he planned on giving the deer to an Amish individual. The deer carcass tag needed his information on it. Mr. Blake didn't have that. So he went and picked him up and brought him back so that that information could be included as necessary. Cleared the scene at 17:07. We have Deputy Taylor at 16:18. He's dispatched directly, and he's en route. And he's told that grandfather's been pushed down by granddaughter. And I think we heard testimony as well that they've had multiple interactions with this family. 16:22, Taylor arrives on scene. And I messed up here. 16:20 should have been up here. But dispatch sends OSP to back up. 17:17, granddaughter is left at home. She's not taken into custody, but the case is going to be referred to the prosecutor's office for consideration of charges. She remains in the home. Nobody was arrested that night. Nobody was taken into custody. At 17:52, Deputy Taylor completes the call. Sergeant Benner did not negligently fail to hold a crime or fail to apprehend an offender in that situation. Didn't happen. She is not responsible for that, and she is not guilty of that count.
Now, moving over here to Deputy Dukes, November 8th, 2022. We have, and I did these on the side for your benefit, because if you do decide to watch the video, the times on the video are this, but this is the actual real time. Again, technology at its greatest. We can't even get our cameras to match time-wise appropriately. So he initiates a car stop at 1849. 1850-ish, you hear him say, "Start me another unit 10" on his radio. 1851, he pulls his service weapon and points it at the people in the car. 1852, Braxton steps out of the vehicle. 1853, Braxton tells Duke that the gun's in the car. 1854, Braxton is cuffed. Duke asks, "Where was the gun?" 1855, Duke puts a cell phone call in that says, "It's Duke, I need more units," and got a man down. 1857, dispatch sends a squad to assist Duke. 1858, dispatch disregards OSP. Now, we have Sergeant Benner. She's at her house for lunch. One of the two houses that she owns over there. 1853, dispatch radio for assistance from Duke going out. 1854, on the dispatch fancy CAD printout thing, it shows Benner en route.
I'm sorry, what was that time?
1854. 1855-ish is when we heard the dispatcher said that they had to use the radio because they hadn't heard back from Benner. They used their radio directly to Benner to call if she had heard the call to assist Duke. Her response is, "Where's Duke's location?" Now, the dispatcher also said normally in a situation like that, a response such as, "What is the location?" is because they didn't get the initial radio traffic. But if you look at their AVL playback detail report, which shows where the cars are, what they're doing, how fast they're going, 1856 shows Sergeant Benner in her cruiser beginning to move at 1 mile an hour. So for the cruiser to be moving at 1 mile an hour, she better well be in it. So from there to 1901, she arrives and assists. And you heard Deputy Duke say she arrived, she did everything expected of her. And in fact, as soon as she shows up, he's like, "Hey, can you watch him?" He specifically asked, "Can you take over watching this guy, Mr. Braxton, on the ground?" We never heard any of that to anybody that arrived to watch this female who was concerned about sitting by herself over on the hill. Deputy Renwick, 1849, he makes his car stop. Interesting, they were on the phone together and they make the car stop at the same time. But he makes contact and he said, I think there was testimony that he collected a license or maybe not, he wasn't sure. But at 1850, he hears Duke's request for additional units 10 over the radio. 1850. 1853, he completes his traffic stop with a verbal warning. I don't know if we kind of weigh, priorities here, car stop versus deer carcass, but in any event, 1854, he's en route to the Duke location. 1906, he arrives at Duke's car stop, after the squad, after Sergeant Benner, after the New London officer, and OSP. In this situation, Sergeant Benner did not negligently fail to halt or prevent a crime or fail to apprehend an offender. She arrived, she got there as quick as she could, she arrived, she assisted, and then she was called out to a priority burglary in process by herself. I think that in looking at all the evidence presented, I think there is a question of the thoroughness of the investigation. I just got to put it out there. Where it started, how it started. And I especially like the comment of Detective Dawson in that he knows enough to be dangerous. And I think that's exactly what happened in this case. Dangerous. Sergeant Benner, Cindy Benner, should never have been charged with these counts. She is not guilty of these counts by a long shot. And it is imperative that upon looking at the evidence and reviewing the evidence, it will be very clear to you that the verdict must be not guilty. And I feel very confident because I'm seeing those Team Cindy shirts still on, and I expect that when you're finished deliberating and you come back, you're going to have those shirts still on, and we're going to hear verdicts of not guilty. Thank you.
Rebuttal, Michelle?
Dangerous is a fantastic word. Fighting with an armed suspect, dangerous. Responding to a domestic violence call, dangerous. You've heard how volatile those situations are. She didn't even respond to one of them. Left another deputy out there by himself to respond to a domestic violence call. The dude's arguing with her, or excuse me, wrestling with an armed suspect. And she's at her house finishing her lunch before she even gets her car to leave. The easiest way to sort out those times is from his body cam. We know exactly when he got on his radio, we know exactly when she showed up, and we know exactly from the GPS how long it took her to get there. 5 minutes. So while he's fighting someone with a gun, she spent 6 minutes at her house. That's all.
All right, thanks, Michelin. Folks, that brings us to the point in the proceedings where it's time for me to give to you or explain to you the law that will apply in this case. And you're going to notice that for the most part as I do that, I'm reading it. And there's several reasons for that. One, it is very important that I be accurate. And if I try to do it from memory, I probably would not be accurate. This is jury instruction is a process, and throughout the course of the proceeding, the court works on these, and counsel have the opportunity to have input if they wish. But you will, the other reason I write them out in detail is I'm going to define some terms for you. I'm going to explain to you the things that the state has to prove in this case. Some of these concepts can be somewhat complicated, and I don't really expect you, as you go back there and you go through 3 days of evidence, to remember all this. So you will have with you in your possession my copy, words and all, that you may refer to as you deliberate. Members of the jury, you have now heard the evidence, and you have heard the arguments of counsel. And it is now my duty to instruct you on the law which applies to this case. The court and the jury have separate and distinct functions. You decide the disputed facts, and the court provides the instructions of the law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of a complaint. The complaint informs the defendant that she has been charged with a crime. The fact that it was filed may not be considered for any purpose. The plea of not guilty, which is the plea entered by Sergeant Benner, is a denial of the charge and puts at issue all the essential elements of the alleged offenses. The legislature of this state requires that the court read to you the definitions that it has adopted for the terms burden of proof and reasonable doubt. The legislature has defined burden of proof as follows. Burden of proof. The defendant is presumed innocent until her guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the crimes charged in the complaint. The legislature has defined the term reasonable doubt as follows. Reasonable doubt. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending upon moral evidence is open to some imaginary or possible doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If, after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, then the state has proven its case beyond a reasonable doubt. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty. Now, evidence is defined under Ohio law, and evidence includes the testimony received from the witnesses and the exhibits that have been admitted during the trial. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts about which he or she testifies. It also includes the exhibits admitted into evidence during the trial. Circumstantial evidence is a proof of facts or circumstances by direct evidence from which you may reasonably and logically infer other related or connected facts which naturally and logically follow according to the common experiences of mankind. Direct and circumstantial evidence are of equal weight. Now, exclusion is not evidence. Evidence does not include the complaint. It does not include the opening statements or closing arguments of counsel. Opening statements and closing arguments are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence. You must be treated as though you never heard them. And you must not speculate as to why the court sustained the objection to any question or as to what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion contained within a question which was not answered. Now, ladies and gentlemen, you are the sole judges of the facts of this case. You are the sole judges of the credibility of the witnesses. You are the sole judges of the weight of the evidence. To weigh the evidence, you must consider the credibility of each witness. And you will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things concerning which he testified, his accuracy of memory, frankness or lack of it, any intelligence, interest, or bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province and your province alone to decide what testimony is worthy of belief and what testimony is not worthy of belief. Now, it is not necessary that the defendant take a witness stand in her own defense. She has a constitutional right not to testify. And the fact that the defendant did not testify must not be considered by you for any purpose. The statute that this defendant is charged with violating is section 2921.44A2 of the Ohio Revised Code, dereliction of duty. And as it applies in this case, That statute reads as follows. No law enforcement officer shall negligently fail to do any of the following. I'm sorry. No law enforcement officer shall negligently do any of the following. Fail to prevent or halt the commission of an offense, or to apprehend an offender when it is in the law enforcement officer's power to do so, alone or with available assistance. So I stumbled over that, so I'm going to read it again. No law enforcement officer shall negligently do any of the following. Fail to prevent or halt the commission of an offense, or to apprehend an offender when it is within the law enforcement officer's power to do so, alone or with available assistance. Now that is the statute the defendant is charged with violating. It's a pretty short statute, but quite a few of the terms within it are defined, and I'm going to read those definitions to you. Law enforcement officer means a sheriff, deputy sheriff, constable, police officer of a township or a joint police district, a marshal, deputy marshal, municipal police officer, member of a police force employed by a metropolitan housing authority under Division D of Section 3735.31 of the Revised Code, or a state highway patrol trooper. Negligently, as used in the dereliction of duty statute, is defined as follows. A person acts negligently when, because of a substantial lapse from due care, she fails to perceive or to avoid a risk that her conduct may cause a certain result. A person is negligent with respect to circumstances when, because of a substantial lapse from due care, she fails to perceive of or to avoid a risk that such circumstances exist. Now, due care is defined, as used in the negligence definition, due care is defined as follows. Due care is that amount of care which a reasonably prudent or an ordinarily cautious person is accustomed to use under the same or similar circumstances. Substantial, as used within the negligence definition, is defined as follows. To constitute negligence, a lapse or failure to use due care must be substantial. The lapse must be a material departure from the standard of due care. If you find that the defendant failed to use due care, you must determine if her failure was a substantial lapse from the standard of due care. Now, the court's defined several terms for you. Other words which have been used during this trial have not been defined. You are instructed that words within the English language, whether used in the charge or in the evidence you are to weigh, are to be given their normal and customary meaning within the English language, unless you have been specifically instructed to give them some specialized or different meaning by the court. The complaint in this case charged the defendant with 4 separate counts of dereliction of duty. Count 1 and Count 4 remain for your consideration and decision. Count 2 and Count 3 have been dismissed by the court. You are not to speculate as to why the court dismissed those 2 counts. You are not to draw any inferences regarding the remaining counts from the dismissals. The dismissal of Count 2 and Count 3 must have no effect whatsoever on your deliberations and decisions regarding the remaining counts. You must decide Count 1 and Count 4 based on the law and the evidence and nothing else, unaffected by the dismissal of Counts 2 and 3. Before you can find the defendant guilty of Count 1, you must find beyond a reasonable doubt that on or about the 3rd day of November 2021 and in Ashland County, Ohio, the defendant was a law enforcement officer and that she negligently failed to prevent or halt the commission of an offense or to apprehend an offender when it was in her power as a law enforcement officer to do so, alone or with available assistance. Specifically in the complaint, it is alleged that on the date in question, as the supervising road deputy of her shift, defendant was made aware by radio communication of a priority call for assistance relating to a domestic violence situation, which by Ashland County Sheriff's Office policy was a two-deputy response situation, that she failed to respond to the domestic violence call even though the location was in her assigned zone. That Deputy Sean Taylor did respond but had to call for his own backup from the Ohio State Highway Patrol because Sergeant Benner declined to leave the call she was on in order to assist Deputy Taylor, said call being for the purposes of issuing a deer carcass receipt for which she spent 30 minutes to do, thereby failing to assist Deputy Taylor in alleged violation of Ohio Revised Code Section 2921.4482. Before you can find the defendant guilty of the fourth count of dereliction of duty, you must find beyond a reasonable doubt that on or about the 8th day of November 2022, and in Ashland County, Ohio, the defendant was a law enforcement officer, and that she negligently failed to prevent or halt the commission of an offense or to apprehend an offender when it was in her power as a law enforcement officer to do so, alone or with available assistance. Now, in that complaint, it's specifically alleged that Deputy Garrett Dude had made a traffic stop near US 224 and State Route 60. That Deputy Dude, upon approaching the vehicle, noticed a male person hiding under a blanket on the floor of the rear seating area of the vehicle, and that he observed the male to have a gun in his waistband. That Deputy Dude immediately made a call for priority response from other deputies. That Sergeant Benner, the supervising road deputy on the shift, was at her house eating lunch at this time, although still on duty, and was the closest deputy to the location of Deputy Dude's traffic stop, which was just a few miles away. That Deputy Winrick in the southern zone was on a traffic stop near Mifflin, Ohio, a considerably greater distance away to be able to assist Deputy Dude. That Deputy Dude became engaged in a fight with the subject male when the male attacked Deputy Dude. The Sergeant Benner never responded to Deputy Dude's radio traffic requesting assistance. That dispatch communicated with Sergeant Benner asking if she had heard the call for assistance, and she responded by asking what his location was. The Sergeant Benner did not leave her house for more than 6 minutes after asking where Deputy Dude was. That Deputy Dude was able to subdue the male attacker with the assistance of citizen passerby. That when Sergeant Benner did arrive, the male was still on the ground and the gun and magazine were in close proximity. That Sergeant Benner just stood there rendering no assistance, necessitating a New London, Ohio police officer who had come to the scene to help Deputy Dude. Sergeant Benner thereby failing to assist Deputy Dude, an alleged violation of Ohio Revised Code Section 2921.4482. Now, those are the allegations in the complaint. During your deliberations, you may not communicate with anyone about this case on your cell phones, through emails, Blackberries, iPhones, text messaging, on Twitter, through blogs, websites, chat rooms, social networking websites, Facebook, or any other computer-related or cell phone-related application. If you find that the state has proven beyond a reasonable doubt all the essential elements of any one or more of the offenses contained in the separate complaints, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate complaints, your verdict must be not guilty as to such offense or offenses according to your findings. The charge set forth in each separate complaint constitutes a separate and distinct matter. You must consider each complaint and the evidence applicable to each complaint separately, and you must state your findings as to each complaint uninfluenced by your verdict as to the other complaint. Defendant may be found guilty or not guilty of any one or all of the offenses charged. Now, you have with you in your jury room 2 sets of verdict forms. The first set applies to count 1. We get number of the counters, so make sure I have the right two. No, that's okay. It's not your fault. Let's see. The first set of forms pertains to the events, alleged events of November 3rd, 2021, which is count 1 in the complaint. First form has a caption of the case, State of Ohio versus Cynthia Benner, case number 23 CRB 00233, charge of dereliction of duty under 29-21-4482, misdemeanor of the second degree. And the first form reads as follows. We, the jury in this case, find the defendant, Cynthia Benner, not guilty of the offense charged in the complaint. Each of us said juror signs his or her name here to this blank day of October, and I'm going to go ahead and write the 6th, Mrs. Schwartz?
Yes, sir.
6th day of October 2023. And then you will see on that form 8 lines, one for each juror to sign, with one juror signing as the foreperson. Second form is exactly the same. It also pertains to count 1. Has the same caption, the same charge. It's different in one significant way. It reads, we, the jury in this case, find the defendant, Cynthia Benner, guilty of the offense charged in the complaint. Each of us said juror signs his or her name hereto this 6th day of October 2023. And again, you'll see one signature line for each juror, with one juror signing as the foreperson. The second set of forms that you have pertains to count 4. Which allegedly is the alleged events of November 8th, 2022 involving Deputy G. First form in that case reads as follows. We, the jury in this case, find the defendant guilty of the offense charged in the complaint. Each of us said juror signs his or her name here to this 6th day of October 2023. And again, there's 8 lines, one for each juror, one juror signing as a foreperson. Second form is exactly the same, but with the opposite result. We, the jury in this case, find the defendant not guilty of the offense charged in the complaint. Each of us said juror signs his or her name here to the 6th day of October 2023, and again, there's 8 lines. Now, no inferences, to be drawn from the order in which I've read those forms to you. I have to read one before the other, and it's my practice to shuffle them face down so that I don't even know which one is on top. When you have reached a verdict, you will complete whichever of those forms corresponds to your decision regarding each of the 2 counts. All members of the jury must sign the selected form in ink. Now, ladies and gentlemen, you have no right to discuss or even consider the subject of punishment. Your duty is confined to the determination of the guilt or innocence of the defendant. In the event you find the defendant guilty on one or more counts, the duty to determine a punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality, and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. Now, if during the course of this trial, the court has, and by the court I mean me, has said or done anything that you consider an indication of the court's views of the facts of this case, you are instructed to disregard that. It is your duty and your duty alone to decide the facts of this case. Now, it may be difficult to remember all the instructions that I have given you. If during your deliberations you cannot remember or you are in doubt about a portion of the instructions, you will have a copy of these instructions. You'll actually have this copy in your jury room to which you may refer. If you still have a question, the foreman or forelady must put your question into writing, indicating specifically what information is requested. That communication must be delivered to the bailiff. However, keep in mind that the court cannot answer questions as to the facts or the evidence, because it is your province to determine the facts and weigh the evidence. It's often said that your initial conduct upon entering the jury room is a matter of importance. It's generally not wise to immediately express a determination or insist upon a certain verdict, because if your sense of pride were to be aroused, you might hesitate to change your position even if you later decide that you were initially wrong. Consult with one another. Consider each other's views. And deliberate with the objective of reaching an agreement, if you can do so, without disturbing your individual judgment. Each of you must decide this case for yourself. However, you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it's wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinions of other jurors. The court will place within your possession the exhibits and the verdict forms. The foreman or forelady will see to it that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreman or forelady is exactly the same as that of any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. Counsel, I have removed the portions that were pertaining to counts 2 and 3. The state desire anything further at this point?
No, Your Honor, thank you.
Attorney Mayor?
No, you're.
After you retire, the first order of business is to select a foreman or forelady. And then when all 8 of you agree on a verdict with respect to each of the 2 counts, counts 1 and 4, and I'll repeat that, all 8, when all 8 of you agree, fill out the form that you select that corresponds with your verdict. Each juror must sign it in ink, and then you will notify Mr. Krause when you reach the verdict by using the buzzer in the jury room, and he will be in his office waiting to hear it. Our practice normally is to have the jury return to the courtroom once Mr. Krause collects everybody else. Normally the foreman would carry it in and hand it to the bailiff, and he would hand it to me, and I will read it in open court. Now, one other housekeeping matter. It is absolutely true that the court will be giving you all 21 exhibits, I believe. Some of them you will be able to view in the jury room. There are 3 exceptions to that. There are 3 compact discs or DVDs, or whatever they are now, that have videos, and one of them has a map. You cannot watch those in the jury room, simply because there's no technology in them to do that. Now, you are welcome to watch those DVDs as many times as you want, or not at all. You have to decide the facts of this case, and you decide if you want to watch those again or not. If you would like to do that, though, there's only one way to do that, and that is by pushing the buzzer for Mr. Krause to come in. He will come out here, and he will make sure the courtroom is cleared of everybody, including me, and he will lock the doors. Mr. Krausman will then assist you in playing whatever portions of the tapes you want to see. If that's all of it, that's all of it, or you can watch any part you want or none of it. what makes that always a bit of a concern for the court is that no one else can be present with you when you are deliberating. You have to deliberate in private. So I have to ask you not to discuss the case in the presence of the bailiff. Mr. Krauser will bring you in, you can tell him whatever you want to see, he'll help you play it, and then he will take you back to the jury room. But you'll need to wait to begin discussing it until you're back in the jury room and he's out and the door's closed. Other than that, you will have everything with you in your jury room. At this point, Mr. Krauser, if you would please speak to the jury.
Okay, sir, all rise for the jury, please.
Yeah.
We have discussion instructions if we have an alternate.
I don't, but I'm going to talk to Mr. Lehman. Thank you.
Thank you.
It's time, Mr. Lehman, as the alternate juror, for you to leave us. And I would say I think you have the worst job in the justice system. Yeah. You sat here for 3 days and listened to all the testimony, and now you don't get to deliberate. But your service has been very important to the court, and we appreciate it very much. Do you have things in there you need to collect?
Yes.
If you want to collect that and then head out, the check will be in the mail.
Mr. Krause, can you hold on a minute? I just have a question before the exhibits go in.
Sure.
I just wanted to uphold.
Sure.
The exhibits related to charges, did they get removed as being irrelevant?
Well, I actually didn't sort the exhibits. It's a good question. You have them all?
I have the staff, I have not looked at the numbers yet.
Are they?
But see, I'm just saying that I know some of them are very specific to dates.
Councilman?
I mean, they're in evidence if the,
I think they're irrelevant at this point as to the other two counts.
Disagree?
I think that you have the jury decide if they want to consider them for the 2 counts that are in.
I think at this point they're uncharged other acts, so I don't think we should go. I will sort the exhibits and we'll send it in.
Okay. And then, like I said, that's my only exhibit that was in.
All right. Everyone else can be seated or do as they please.
I'm going to take out
I want to stay on the record because I'm going to have counsel help me with these exhibits.
Okay, sir.
Do you want to give them the form? Tell them to send in the exhibits that remain relevant.
Okay, hang on.
For now, I will.
Okay.
So the dates in play are 11/8 and count 1, which is
November 3rd, 21.
November 3, 21.
November 8, 22.
All right, I'm going to put these back in chronological order. Okay. One is Mr. Halverson's affidavit, which I think clearly applies to all counts. 2 is the map read by Deputy Wood, which applies to the Duke situation. Does it not? No? Which one?
It was the suicidal male.
Okay, so that 2's out. 3 is November 3, 21, which is count 1. 2 is it. 4 is the policy manual, which I think would apply to everything. 5 is Sergeant Benner's oath, which should apply to every count. 6 is November 2, 22, which is count 2, I think. But it's not 1 or 4. So that one's out. Let's see, 8
Do we skip?
is the CFS call for service October 27, 22, so that's either 2 or 3.
Do we skip 7?
What's that?
Do we skip 7?
I don't know.
It should be the,
7 is the
right.
radio traffic from October 27. Well, it's dated 10/20. What it says on the outside is 10/27/18/17
That's
Yeah.
the account dismissal.
Alright. 9 is the CFS from the Duke situation, 11A.
Judge, we skip 8.
I don't think so.
Or do you already put that in?
8 is out.
Rick, can you ask the jury to just take a break?
Sure.
I don't want them to start their deliberations in earnest until they have.
Okay.
I have 8 as being the 10/27/22 call for service, which I thought we dealt with.
Okay.
Okay, hang on.
10 is the call for service dispatcher Starkey from November 3/21, so that should be in. 11 is the DVD, which I believe is the dash cam from, the body cam from deputy.
Yes.
So it's, 12 is your deer carcass receipt, which pertains to count 1, so it would be in. 13 is a call for service 10/27/22, which would be count 3, I believe, so this should be out. 14, 10/27/22 ABL playback, so again, I believe that should be covered. 15, 11/2/22 ABL playback, which also pertains to this count. 16 is the map, which is the alleged suicidal man with the gun, which should be out. 17 is an ABL pertaining to Sergeant Benham from the date of the Duke situation. That one should be in. Eighteen is a map showing Deputy Winrick's route and Sergeant Benner's route to the Duke traffic stop, so that pertains to count 4, should be there. 19 is the GPS coordinated map showing the same thing, so that should be in. 20 is the personnel report, that should be in. I think that exhausts the state's exhibits.
I didn't realize that he asked for 20 to go into evidence.
Yeah, I admitted 20.
Okay.
And your exhibit should be in, right?
Yes, and I just have the one.
All right. Definitive meeting. Okay. All right, there you go. Gotcha.
Okay, sir.
The exhibits for the record that are not going back to the jury.
Okay.
6, 7, 8, 13, 14, 15, and 16, as well as 2.
Okay.
I'm delivering in your possession for the record.
Okay, and I will also then take them off my log as part of this, present to the jury.
Any further counsel?
Yes, sir, thank you, Judge.
All right, we're going to same thing with the jury instructions, the 2 that I would say. Part of the record.
Sure, you have the record.
All right, we're back on the record. The state versus Benner. Parties are present with counsel. Mr. Crossman, jury's reached a verdict.
Yes, sir, they have.
Would you return them to the courtroom, please?
Yes. All rise for the jury, please. Let's go ahead and sit down, okay? Thank you.
Good seeing everyone. Mr. Wilcox, looks like you're the foreman. Did you jury reach the verdict, sir?
We have.
Could you hand it to Mr. Crossman, please? Thank you. All right, the court reviewed the jury forms with respect to counts 1 and 4 of the complaint, and they appear to be signed by all 8 jurors in ink as required, and that includes by Mr. Wilfong as the foreman. First form, as it pertains to count 1, charge of dereliction of duty, alleged violation of 2921.44A2, a misdemeanor of the second degree. The verdict form reads as follows. We, the jury in this case, find the defendant, Cynthia Benner, guilty of the offense charged in the complaint. Each of us, said juror, signs his or her name hereto this 6th day of October 2023. Second complaint, as it pertains to count 4, second charge, rather, second jury verdict form, as it pertains to count 4 of the complaint, reads as follows. And this is with respect to the November 8, 2022 incident. Also a misdemeanor of the second degree. We, the jury in this case, find the defendant, Cynthia Benner, not guilty of the offense charged in the complaint. Each of us, said juror, signs his or her name hereto this 6th day of October 2023, and again, it appears to be signed in ink by all 8 jurors with Mr. Wilfong as the foreman as required by law. Mr. Long, you desire to have a jury report?
Yes, sir.
Do you, Attorney?
No, you're.
Court is going to accept both of the verdicts and order them journalized as orders of the court. Mr. Wilfong, just so we have it on the record, apparently there was a mistake at some point.
2 mistakes, Your Honor.
I'm sure I've made more than 2. But you started filling out the wrong forms.
That's correct.
It looks like you had them crossed up. Is that right?
We did.
Now, I'm going to make those 2, I'm going to call them aborted forms, part of the record as well. But just so that I understand it, and it's clear, it looks like originally you started doing not guilty on count 1, guilty on count 4, and then changed it to guilty on count 1 and not guilty on count 4.
Actually, Your Honor, we actually did the guilty form first incorrectly, and then we did not guilty on the other one before we did the
But
correct form.
just so I'm clear,
Yes.
and everyone is clear, the intention of the jury was guilty on 1, not guilty on 4.
That is correct.
All right. I see 9 heads nodding. So court is going to accept those over and journalized. Count 4, it's normally the practice of the court, and I'm not going to make a long speech, it's 2:30 and we've been here for 3 days, and your service is greatly appreciated. This has not been an easy case, not been easy for the court. I'm sure it wasn't easy for any of you, and we can tell that by the effort you put in, by the emotion on your faces, by the length of time that you took. This isn't easy, not easy for the defendant either, I'm sure. Normally, because of that, it's this court's practice to impose sentence right immediately upon receiving the verdict, because I think that the jury should hear the sentence. They're the ones who return the verdict. And by that point, I've heard the evidence, so I feel like I'm in a position to do it. We have a constitutional amendment in this state now under Marcy's law that gives victims of crime the right to be present at all times and the right to be heard before the court imposes sentence. And I have considered that if there was a guilty verdict on count 4, that I should allow Deputy Duke an opportunity to be heard as a potential victim of that offense before I impose sentence. But since there is a not guilty on count 4, and it appears to me that in count 1, the victim is the community. You know, the victim of a dereliction of duty is the community. And I think I'm going to go ahead and proceed with sentencing unless there's some reason not to, Teresa.
I think a sentencing memorandum may be appropriate in this matter, and I would like to have an opportunity to do that with that sentencing at a later date.
Thoughts on sentencing, Mr. Long?
We're prepared today, Judge. You've heard the case. I think you know it well enough to impose a sentence.
What's going to be in the sentencing memorandum that you can't tell me about today?
There isn't.
I'm not trying to put you on the spot here, but I know Sergeant Benner has no criminal history.
Yes.
I wouldn't see a need to do a PSI in this case. I mean, if it's something that if you're looking to do character letters or something that you don't have with you today, I'll give you that opportunity. I guess I just want to know why. What is it that will be different if I don't do it today?
There wasn't, Judge. We can proceed.
Is there anything else you'd like to say on behalf of Sergeant Benner?
Yes, thank you, Your Honor. In my months of working with Cindy Benner, I've been very impressed with her professionalism and her love of her job and her devotion to that job. She has been with the Sheriff's Office for over 30 years, from dispatch to jail to sergeant. She has been demoted as a result of the allegations in these matters, and she currently is posted in the jail, so obviously that demonstrates the Sheriff's Office, and the Sheriff has great respect for her and her training and her abilities as she's training individuals at the jail where she works in central control. I think the situation that the jury found her guilty of involved where she was already dispatched, and I think that the fact that the OSP was called as backup, she was on a call. I don't think that they're, especially in light of the fact that the deputy that did go take over was very quickly in touch with dispatch, and in fact dispatch let them know there were no weapons, there was nothing involved, that this was a discretionary decision made by a sergeant, and we think that, especially in light of her record and her exemplary basically history with the Sheriff's Office, I think it's also, the court did see her recommendations as the years have gone on, and again, I think she was here longer than anybody who testified, except possibly the Sheriff. So I think that all of that's important to say, that I feel the court, by way of sentence, I don't believe that probation would be necessary, truthfully, but that would be up to the court and in the court's discretion. Thank you, Your Honor.
Sergeant Benner, or I guess Deputy Benner at this point, is there anything that you would like to say? No. Okay. Well, I don't have to accept that, you know. It's always been my opinion that people don't have to speak at sentencing if they don't want to, but there is, if there is anything that you want me to know about this before I impose sentence, since you exercised your right not to testify in this trial, the court has not had the opportunity to really hear your side of it. I mean, I've heard it, you know, by hint through other testimony, cross-examination mostly. But I would be interested in hearing your side of it, and it might make a difference in what I do. So, if you don't want to speak, you certainly don't have to. But it would be helpful to me to hear your version of events on November the 3rd of 2021. And I understand that's 2 years ago, almost. But if there's things that you remember about that you would like to say, I'd be interested in hearing them. Now, I know there may be other things going on, administrative things and otherwise, that may be compelling you not to speak, and the court will respect that if that's where you're at. Yes, no?
Sir, I know this is hard for him, that's why I just.
No, I understand that too, and I'm not, if you don't want to speak, you absolutely do not have to. I would just, if I'm going to impose sentence in this case, which I am, it'd be helpful to me to hear your side of it.
That day, it was a decision that I have made. I stuck behind it. My job, knowledge, training, experience, the way that we handled calls, it was normal to call the post if other units were tied up on a call, and I just did that. I was having issues with Deputy Taylor. He didn't want to listen to some of the stuff that I told him to do. I actually approached Lieutenant Sims, Captain Sims, about those issues and wanted to take care of some of them, but I was not allowed to put there any of that stuff.
Okay.
And that's the officer that is no longer working.
Yeah, and he's no longer working at our department.
Yeah. Okay. Thank you, Deputy. Any other input from the state?
Yeah, Judge. The deputy that they're speaking about quit because of Sergeant Benner. Now Deputy Benner. I had another deputy ask me if he had to get shot before she was held accountable. Another one came to my office and said the way that she polices is arrest people for police to die. Heard all of that. The 90 days that the court has available to it is so demeaning to the harm that she put people in, even if you impose it. But I really don't think the deputies care. They just wanted her off the road. And thankfully, because of this, she'll never be a road deputy in charge of anyone again. And that's justice.
Thank you, Sean. Well, everyone has draws their own opinions about things based on what they see. And we all had the opportunity to see Deputy Taylor testify and the way he conducted himself. So there are probably some people that are right. He's not at the Ashland County Sheriff's Department anymore, if that's how he acts. That being said, I have to sentence the defendant for what she did, not for what deputies say she did, or what deputies wish they could prove she did, or what other things that people want to bring up. I have to sentence her for what she's been found guilty of. And she has been found guilty of a criminal offense. And that is a serious thing, and that carries it's a second-degree misdemeanor. It carries very real consequences for a law enforcement officer, as it would for other people, just by its nature. And it is a second-degree misdemeanor. It is a minor offense. The maximum penalty is 90 days in the county jail and a fine of up to $750. She's not been found guilty of murder or causing people to die. She's been found guilty of dereliction of duty involving a domestic violence case that was handled by another deputy while she was at a different call. That's what the court will be sentencing her for. Now, it was very hard to sit here and watch that video of that kid, Deputy Duke, fighting for his life in the darkness. Very hard to watch. Sure, it was hard for the jury to watch too. But the jury found her not guilty of that offense. And what that means is she is not guilty of that offense. And this court will not be sentencing her for what happened with Deputy Duke because she wasn't found guilty of that.
Thank you.
Nor will I be taking that into consideration or any of the other innuendos or the other things that people are saying online or whatever else people want to bring up. In this court, you get sentenced for the crimes that you're found guilty of and for nothing else. And that's what she'll be sentenced for. Now, that is a second-degree misdemeanor, equivalent to obstructing official business or resisting arrest. That's what we're talking about. Not to make light of it, because I know for you it has significantly better consequences. The case, the charge that we're talking about, was 2 years ago. 2 years ago, when this defendant was at another call involving a dead deer. A call came in for a domestic. Deputy Taylor went to that call. She did not respond to that call. Deputy Taylor handled the call. No one was arrested. No one went to jail. No one escaped. No crimes were failed to be permitted or committed. The whole thing was handled to the satisfaction of, as far as I know, everybody. So, should this defendant have handled that differently? Absolutely. The court shares the jury's, for what it's worth, doesn't matter what I think, but I share the jury's opinion that she could have handled that better. But that's what we're talking about, not all these other things. We're talking about not responding to a domestic that another officer was handling when the case was resolved and a charge was filed. That's what we're talking about. Is a jail sentence appropriate and necessary for that? Not by any standard of justice this court's familiar with. I'm going to assess a fine in the amount of $500. I'm going to require that the defendant complete 80 hours of community work service. It's really the community that suffers here. When the law enforcement officer doesn't do their job in a way that we as a community expect, it's the community that suffers. The debt is to the community. So we're going to require that the defendant complete 80 hours of community work service. I will give her until March the 1st of 2024 to get that done. Now, I'm not going to put you on probation. I don't believe it's necessary. We're talking here about a 58-year-old, 59-year-old woman who has never, prior to this, committed a criminal offense in her life, who has lived a law-abiding life and a life of public service. And I'm going to count that. I'm going to give you credit for that. I don't believe you're a danger to the community. I don't believe you need to be on supervision. And I don't think a jail sentence is warranted based on the actual evidence that the court heard in this case. And that will be the end of it. What you'll need to do is stop over and see Mr. Fulmer, who runs the Community Work Service Program. And he will get you signed up for your work service, and he'll go through all the details, all the terms and conditions of the Community Service Program. Anything further from the state?
No, sir.
Anything further from you, Attorney Mayor?
No, Your Honor, thank you.
Ladies and gentlemen, there is no way the court can express to you how much it appreciates your service in this case. Everybody said it. We don't do 3-day trials. It's a rare event. This was an important case, and your service is very much appreciated. Mrs. Wirtz has your woefully inadequate checks, and she will distribute those in the jury room. Thank you again.
Sir, your record is on.